The moment I walked through those courtroom doors alone, my ex-husband laughed. Not a quiet, polite laugh, a loud, open-mouthed laugh that bounced off the marble walls and made every head in that room turn toward me. His attorney leaned over and whispered something in his ear, and then they both laughed. I stood there in a plain gray blazer, a small leather folder tucked under my arm, no legal team behind me, no briefcase, no assistants, just me. And I smiled. That smile made him laugh harder. He had no idea what that smile meant. He had no idea what was inside that folder, and he had absolutely no idea that the judge sitting at the front of that courtroom had once shaken my hand and said words to me that I had never forgotten. Words that I had earned over 22 years of service that my ex-husband knew nothing about. Nothing real, anyway. Stay with me. Because what happened in that courtroom on a cold Tuesday morning in November is something I still think about every single day. Not because of what I won, but because of what finally came to light. The truth about who I really was and why I had kept it buried for so long. My name is Margaret, but the people who matter most to me call me something else. They call me Colonel. And this is my story. If you are new to this channel, welcome to The Quiet Colonel. We tell stories here about people who were underestimated, overlooked, and pushed to the edge, and then we watch what happens when the truth finally comes out. If this kind of story speaks to you, please take a moment right now to subscribe and hit that bell. It means everything to us, and it means you will never miss another story like this one. Now, let us go back to the beginning. I grew up in a small town in rural Ohio, the kind of town where everybody knew your family, your business, and your mistakes before you even made them. My father was a mechanic. My mother was a school nurse. We were not rich, we were not powerful, but we were honest, and we worked hard, and my parents made sure I understood from a very young age that your character was the only thing that truly belonged to you. I was 17 years old when I walked into a military recruitment office on a Thursday afternoon after school. I had not told my parents. I had not told my friends. I had been sitting with this decision alone for almost a year, turning it over and over in my mind the way you turn a stone in your hand, feeling every edge. And on that Thursday, I walked in, sat down across from a sergeant who looked like he had seen everything twice, and I said, "I want to serve." He looked at me for a long moment, and then he said, "Young lady, do you have any idea what you are signing up for?" I said, "No, but I'm ready to find out." He smiled at that. Not the kind of smile that made me feel small, the kind of smile that made me feel like I had passed some invisible test. What followed were 22 years that I will spend the rest of my life trying to describe, and probably never fully succeed. Basic training, advanced training, deployments that took me to places I cannot name, doing work I cannot fully explain, in service of a country that most of the time didn't even know I existed. And that was fine. That was more than fine. That was exactly what I had signed up for. I rose through the ranks, slowly at first, then with a momentum that surprised even me. I earned commendations, I led teams, I made decisions under pressure that still visit me in the quiet hours before dawn. And eventually, after many years and many miles and more sacrifice than I ever expected to carry, I was promoted to colonel. I want to be honest with you. I am not telling you this to impress you. I'm telling you this because the woman who walked into that courtroom alone, who my ex-husband laughed at, who his expensive attorney dismissed with barely a glance, that woman carried all of those 22 years inside her, and nobody in that room knew it. Nobody, except the judge. But I'm getting ahead of myself. I met Daniel when I was 34 years old. I was between deployments, stationed stateside, running a training program that kept me busy, but also gave me something I hadn't had in years, a normal schedule. I met him at a charity fundraiser for veterans that a friend had dragged me to. He was handsome, charming, and he had a way of looking at you like you were the only person in the room. He was a successful real estate developer. He wore nice suits, he opened doors and pulled out chairs and said exactly the right things at exactly the right moments. I should tell you that I was not naive. 22 years in the military had made me many things, but naive was not one of them. I had read people for a living. I had sat across tables from some of the most dangerous and deceptive individuals on the planet and identified what they were hiding. And yet, somehow, with Daniel, I got it wrong. I have spent a long time asking myself how that happened. The best answer I have ever been able to come up with is this: I wanted it to be real. After so many years of missions and operations and work that required me to hold everything at arm's length, I wanted something that was just mine, something warm and ordinary and human. Daniel offered me that, or at least the version of Daniel that he showed me offered me that. We dated for 2 years. I was careful about what I shared with him about my career. I told him I worked for the government in a management role, that I traveled a lot, that some of what I did was classified and I could not discuss it. He seemed to accept this. He said he respected it. He said he was proud of me. We got married in the spring, in a small ceremony with close friends. My commanding officer sent flowers. My parents were there, beaming. It was, for a moment, everything I had ever quietly hoped for. Then things began to change. It started slowly, the way these things always do. A comment here about how much time I spent away, a complaint there about how I could not always share the details of my work. The warmth in his voice when I called from wherever I was stationed began to cool, degree by degree, until it was something flat and obligatory. I told myself it was the stress of his work. I told myself it was the distance. I told myself 100 things that were not true, because the truth was something I was not ready to look at. The truth was that Daniel had never really seen me. He had seen the version of me that fit neatly into the life he wanted, a partner who was accomplished enough to impress his colleagues at dinner parties, but who would ultimately defer to him, depend on him, orbit around him. When it became clear that I was not that person, he did not adjust. He started to resent. By the time I retired from active duty, our marriage was already broken in ways I was still pretending I could not see. I came home for the last time with my uniform, my medals, my 22 years, and the quiet dignity of a life I had given everything to. I walked into our house expecting, I don't know what I was expecting, something. Some acknowledgement, some recognition of what I had carried. Daniel barely looked up from his laptop. "Welcome home," he said, and then he went back to typing. 6 months later, he handed me divorce papers. He had a new attorney, a new girlfriend, and a very old approach to taking everything he could in the settlement. The house we had bought together, the investment accounts, the retirement funds I had spent 22 years earning. He wanted all of it. And he sat across the table during the mediation sessions with a look on his face that I recognized immediately. It was the look of a man who believed he was dealing with someone who had no power. I signed nothing. He escalated to litigation. He hired one of the most aggressive divorce attorneys in the state, a man named Gerald Voss, who had a reputation for taking no prisoners and leaving nothing on the table. When my attorney, a quiet and competent woman named Susan, withdrew from the case due to a family emergency, I found myself standing at the edge of the most important legal battle of my life without representation. I could have hired someone else. There were other attorneys, but something happened in that moment, something that I can only describe as a kind of clarity. The same clarity that used to come to me in the field when everything was chaos and noise and pressure, and suddenly you could see exactly what needed to happen next. I looked at the situation, I looked at what I had, and I decided to represent myself. Everyone around me told me this was a mistake. My friends, my sister, even Susan, calling from her own crisis, told me I was making a terrible error. Daniel's attorney sent a letter that was barely professional in its barely concealed delight, and Daniel himself, when he heard, apparently found it so amusing that he told people about it at dinner parties. I did not mind. Let them laugh. I had been underestimated before, and I had learned, a long time ago, that underestimation is one of the most powerful advantages a person can have. I spent 6 weeks preparing for that courtroom. I read case law until my eyes burned. I organized documents with the precision of someone who had planned operations in environments where a single overlooked detail could mean catastrophe. I built my case the way I had built everything in my career, methodically, quietly, and with absolute certainty about the outcome I was working toward. On the morning of the hearing, I put on my plain gray blazer. I picked up my leather folder. I drove to the courthouse alone. And when I walked through those doors and Daniel laughed, I smiled because I knew something he did not know. I knew what was in my folder. I knew what was about to happen, and I knew that the judge sitting at the front of that courtroom was the Honorable Richard Caldwell, retired Brigadier General, United States Army, a man who had personally signed my promotion papers 12 years ago, and who, the last time I had spoken to him, had shaken my hand and said, "Colonel, it has been an honor." The bailiff called the room to order at exactly 9 a.m. I took my seat at the respondent's table, set my folder down carefully, folded my hands on top of it, and looked straight ahead. At the plaintiff's table, Daniel sat with Gerald Voss, who was already shuffling through an impressive stack of legal documents, with the practiced confidence of someone who had never lost. Daniel leaned back in his chair with the relaxed posture of a man attending a show he had certainly seen the ending of. Judge Caldwell entered the courtroom. Everyone rose. I rose with them, and for the first time since I had entered the building, I looked directly at the judge. He was 63 years old now, silver-haired, with the kind of posture you cannot fake, the posture of someone who had spent decades standing at attention. He moved to the bench with the measured economy of motion that I recognized from a lifetime of working alongside military men and women. He set his papers down. He looked at the room. His eyes moved to the plaintiff's table, then to mine, and they stopped. It was barely a second, less than a second, perhaps, a flicker of recognition so fast that I doubt anyone else in that room caught it. But I saw it, and Judge Caldwell, to his complete and utter credit, revealed nothing further. His face returned to the composed neutrality of a man who had seen everything and could not be moved. He adjusted his glasses. He looked at his papers. "We are here today in the matter of Hargrove versus Hargrove," he said. His voice was exactly as I remembered it, quiet but absolute, the kind of voice that filled a room without effort. "Mr. Voss, you represent the plaintiff?" Gerald Voss rose immediately. "That is correct, Your Honor." "And the respondent?" Judge Caldwell looked at my table. I stood. "Margaret Hargrove, Your Honor. I am representing myself." There was a ripple through the room. A few people in the gallery shifted. Voss barely suppressed a smile. At the plaintiff's table, Daniel turned to look at me with an expression that was equal parts amusement and pity. Judge Caldwell looked at me for a moment. Then he said simply, "Very well. You may proceed, Mr. Voss." Voss was good. I will give him that. He was smooth and precise, and he had clearly spent a great deal of time preparing a narrative that painted me as the absent party in our marriage, always traveling, always unavailable, always prioritizing my work over my husband and our home. He presented documents, he cited precedents. He moved through his opening with the fluid confidence of someone who had given versions of this speech many times before. I took notes. Quiet, careful notes in the margins of the legal pad I had brought. I did not react. I did not shift in my chair. I had sat through briefings in rooms where the information being shared could have ended careers and changed the course of operations involving hundreds of people, and I had learned to absorb and process without allowing anything to show on my face. This was no different. This was simply another environment where I needed to listen carefully and wait for the right moment. When Voss finished, Judge Caldwell looked at me. "Ms. Hargrove, your opening statement." I stood. I had thought a great deal about how to begin. I had written and rewritten the opening a dozen times, and in the end, I had decided on the simplest possible approach, because simplicity, in my experience, was almost always the most powerful thing in the room. "Your Honor," I said, I spent 22 years serving this country. I will not take long. I am simply here to make sure that what I earned during those 22 years is correctly and fairly accounted for. I have the documentation, I have the facts, and I am confident that this court will arrive at a just conclusion. I sat down. Voss was already leaning over to whisper something to Daniel. Daniel was smiling again. I heard the word amateur in Voss's whisper, not clearly enough to be certain, but clearly enough. I wrote something on my legal pad. I underlined it twice. The morning proceeded. Voss called Daniel to the stand first, walking him through a carefully constructed account of our marriage, the sacrifices Daniel had made, the opportunities he had passed up, the emotional toll of being married to someone who was, as Daniel put it with remarkable smoothness, more committed to her work than to us. It was a polished performance. Daniel was a charming man. He always had been, and in the witness box, he deployed that charm with surgical precision. Then it was my turn to cross-examine. I walked to the podium with my legal pad and a small stack of documents. I looked at Daniel for a moment. He met my eyes with the easy confidence of a man who believed he was untouchable. "Good morning, Daniel," I said. "Morning," he said, casual, dismissive. "You testified that I was, in your words, more committed to my work than to our marriage. Is that correct?" "That's correct. And you characterized my work as government management of an unspecified nature." "I only know what you told me." "Which was?" "That you worked in government management, that it was classified, that you couldn't really talk about it." "I see. And in 12 years of marriage, you never once asked me to tell me more? You were satisfied with that explanation?" He shifted slightly. "I respected your privacy." "That's very generous of you. Let me ask you something else. You testified that you provided the primary financial stability for our household during periods of my absence. Is that your position?" "Yes." I reached into my folder and removed the first document. I placed a copy on the exhibit table for the clerk and turned to face Daniel. "I am going to show you what has been marked as Exhibit A. This is a detailed record of deposits made to our joint household account from January of our first year of marriage through the month of our separation. Would you take a look at that, please?" He looked at it. His expression did not change, but something behind his eyes did, something small and quick, like a light going off in a room at the end of a hallway. "These are financial records," he said. "They are. Can you tell the court what percentage of the total household deposits during our 12-year marriage were sourced from my income versus yours?" Voss was on his feet immediately. "Objection, Your Honor. The respondent is asking the witness to perform a mathematical analysis of documents without adequate time to—" "I can answer," Daniel said, cutting his own attorney off. There was an edge in his voice now, something that had not been there before. He looked at the document again. "It looks like the contributions were roughly comparable." "Comparable," I repeated. "Your Honor, if it pleases the court, I would like to note for the record that according to these financial statements, which I have certified copies of from our joint banking institution, my income accounted for 68% of total household deposits over the course of our marriage. Daniel's income accounted for the remaining 32%. The room was quiet. I continued. "Furthermore, I would like to draw the court's attention to Exhibit B, which is a summary of my federal retirement account, my thrift savings plan, and the pension I accrued during 22 years of active military service, assets that Mr. Voss has requested be divided equally in this settlement, on the grounds that they constitute marital assets." I paused, just for a moment. "Your Honor, I began my military service at age 17, 3 years before I met Daniel, and 17 years before we were married. The majority of my retirement benefits were accrued during active duty service that predates our marriage by decades. I have the service records here. I have the contribution timelines. I have everything." Voss was on his feet again. I and him went back and forth through objections and rulings for the next 40 minutes, and I will not walk you through every exchange. What I will tell you is that by the time we broke for lunch, the easy confidence at the plaintiff's table had been replaced by something quieter and more careful. Daniel was leaning close to Voss, speaking in a low, urgent voice. Voss was nodding slowly, his earlier smugness replaced with the focused expression of a man recalculating. During the lunch recess, I sat alone in the corridor outside the courtroom with a cup of coffee from the vending machine and my legal pad. I reviewed my notes for the afternoon. I was not nervous. I had been in more difficult rooms than this one. But I will be honest, there was a moment, sitting in that corridor with the fluorescent lights above me, where I felt the weight of everything. Not fear, not doubt, just weight. The kind that comes with caring deeply about the outcome of something. 22 years, every early morning, every deployment, every sacrifice, all of it distilled into a folder of documents and a morning in a courtroom. I finished my coffee, I went back in. The afternoon session was where everything shifted. Voss, regrouped from lunch, came at me with what I suspected was his trump card, a forensic accountant he had retained to testify that my retirement assets, regardless of when they were accumulated, had been commingled with marital finances in ways that made complete separation legally complicated. It was a sophisticated argument. The accountant was credible and precise, and for about 20 minutes, I could feel the momentum in the room tilting away from me. Then it was my turn to cross-examine the accountant. I had anticipated this argument. I had spent 3 nights preparing for exactly this argument, and what I had prepared was not a counter-argument so much as a series of very specific, very pointed questions that I had learned during 22 years of intelligence work was the most effective way to dismantle a position, not by attacking it head-on, but by asking the questions that revealed what it was built on. I walked that accountant through his own methodology, step by step, until he was forced to acknowledge that his analysis had relied on a set of assumptions about the commingling of assets that were in 2 specific and documented instances factually incorrect. I showed him the bank records. I showed him the transfer logs. I showed him the timeline. By the end, the accountant looked like a man who had walked into a room expecting to give a presentation and had instead found himself in an oral examination he had not studied for. Voss objected 4 times. Judge Caldwell sustained 1 of them. The other 3 he overruled with the quiet finality of a man who had made up his mind about something. It was at the end of the afternoon session, as we were preparing to recess until the following morning, that everything in that courtroom changed. Not because of a legal argument, not because of a document, because of something far simpler than that. One of Daniel's witnesses, a colleague of his named Brooks, who had been called to testify about the character of our marriage, made a comment during his testimony. He was trying to support Daniel's narrative about my absences and my unavailability. He was saying that in his experience of knowing us as a couple, I had always seemed more like a soldier than a wife. He meant it as a diminishment. Judge Caldwell set down his pen. He looked at Brooks for a long, steady moment. Then he looked at me, and I saw it again, that flicker of recognition, more visible now, not because the judge had lost his composure, but because something in the testimony had made something click for him, something that connected the woman sitting at the respondent's table, alone with a plain gray blazer and a leather folder, to the officer he had known. He looked back at Brooks. He said very quietly, "More like a soldier than a wife?" Brooks said, "Yes, Your Honor. I just meant, I understood what you meant." And then he called recess. That evening, I went home to my apartment, not the house. I had moved out months ago. And I made dinner and sat at my kitchen table with my notes, and I did something I had not done in a long time. I let myself feel it, all of it, the exhaustion and the anger and the grief that was still there underneath everything, quiet but present. Because no matter how prepared you are, no matter how clearly you can see the path through something, divorce is still the end of something you believed in, and believing in something and watching it end is a particular kind of loss that does not care how capable you are. I sat with it. I gave it its full due, and then I put it away, because the second day of the hearing was going to require everything I had. I was back in the courtroom at 8:45 the next morning. Daniel and Voss arrived 5 minutes later. Daniel looked at me with an expression that had changed from amusement to something harder and less readable. Voss went directly to his documents without looking at me at all, which told me that the previous day had registered more than he wanted to show. I was ready for what was coming. What I was not fully ready for was what happened before the session officially began. A clerk approached my table and handed me a small folded note. I opened it. There were 4 words on it, written in a clear, angular hand that I recognized immediately. See me in chambers. I looked at the bench. Judge Caldwell was not yet seated. I looked at Voss. He had not received a note. I folded the paper carefully and put it in my folder. 10 minutes later, I was standing in Judge Caldwell's chambers while he sat behind his desk in his robe, his glasses on, looking at me with the expression of a man choosing his words with great care. "Colonel," he said, just that one word, my rank, my title, the one I had earned in 22 years, the one that was never mentioned in that courtroom, the one that almost nobody in my current civilian life even knew. I felt something move through me, the way the ground shifts almost imperceptibly before something significant happens. "Your Honor," I said. He studied me for a long moment. Then he said, "I want to be very clear about something. This conversation is procedurally irregular, and I would not be having it if I did not believe it was necessary for the integrity of these proceedings. What I am about to ask you is a matter of full disclosure, and it will affect how I proceed today." "Of course," I said. "I have been reviewing my notes from yesterday's session, and I believe I may have prior knowledge of the respondent in this case in a professional capacity. I am obligated to disclose this to both parties and to offer to recuse myself if either party believes it creates a conflict of interest." He paused. "But before I do that, I need to confirm that my identification is correct. Are you Colonel Margaret Hargrove, formerly of the United States Army Operations Division, the officer who was awarded the Distinguished Service Medal in 2019 for actions during a classified operation that I was briefed on in my capacity as Brigadier General Caldwell?" The room was very quiet. "Yes, Your Honor," I said. He nodded slowly. He took off his glasses and set them on the desk. He looked at his hands for a moment, then back at me. "I will be disclosing my prior professional relationship to both parties this morning. Mr. Voss will almost certainly move to recuse. I want you to know that I will honor that motion without prejudice. This is not about me, and it is not about what I know of your record. This case will be decided on the evidence and the law. What I will not allow, regardless of who presides, is for this proceeding to continue without the full facts on the record." I understood exactly what he meant. "There is information about the nature of your career," he said carefully. "Information that is relevant to your contributions, your earnings, and the characterization of your absences during your marriage that I believe has not been properly entered into the record. Is that correct?" "Yes, Your Honor." "Are you in a position to provide documentation?" "I am." He put his glasses back on. He stood up. "Then let us proceed." When we returned to the courtroom, Judge Caldwell called both parties' attention to the disclosure. He explained in precise and measured language that he had prior professional knowledge of the respondent and that he was disclosing this in the interest of full transparency and procedural integrity. Voss was on his feet before the judge had finished speaking. He moved to recuse immediately. Judge Caldwell nodded and noted the motion for the record. He informed the parties that a ruling on the recusal would be made after a brief recess, during which he would contact the court administrator. But before the recess, he said something else. He said, "Before we pause proceedings, I want to ensure that the evidentiary record of this case is complete. Ms. Hargrove, you have indicated that there is documentation relevant to your professional background and career history that has not yet been entered into evidence. I am going to ask you to present that documentation now before any transfer of jurisdiction, so that it is part of the record regardless of who ultimately presides over this matter." Voss objected. Judge Caldwell looked at him. "Overruled. The court has a responsibility to ensure that the factual record is complete. We will proceed." I opened my folder. What I had inside that folder, what I had been carefully preparing to introduce at the right moment, was a complete and unredacted record of my military career. Not the classified portions, which I had never expected to use, but everything that was a matter of public record. My rank at retirement, my salary history across 22 years, the commendations, the length and nature of my service, the retirement benefits I had earned, the pension calculation. But more than that, what I had was a character evaluation, a formal assessment written by my commanding officers over the years that spoke to my judgment, my integrity, my leadership, and my commitment. Words written by people who had seen me at my best and my worst, and concluded, in the formal language of military assessment, that I was someone of exceptional character and capability. I handed the documents to the clerk. He distributed copies, and I watched Gerald Voss receive his copy and begin to read. I watched his face change. It is a particular thing to watch someone realize that they have fundamentally misjudged a situation. I have seen it in operational contexts where the realization came with serious consequences. Here, in a courtroom, the consequences were different, but the expression was the same. A stillness that was not calm, a recalibration happening in real time, behind a carefully maintained exterior. Daniel was looking at the documents too. He was not maintaining his exterior. His face had gone through several expressions in rapid succession: confusion, then surprise, then something that looked almost like disbelief. He leaned over to Voss and said something in a low, urgent voice. Voss put a hand on his arm. Daniel sat back. Judge Caldwell looked at the room. He looked at me. And then, for the first time in 2 days of proceedings, he did something that I had not expected and will never forget. He stood up. Not to leave, not to call a recess. He simply stood. And in that courtroom, the bailiff's voice rang out immediately, as it always does when the judge rises. "All rise." Everyone rose. Judge Caldwell remained standing for a moment, looking at the room. Then he looked directly at me and gave a single, almost imperceptible nod, the kind of nod that one person gives to another when words are unnecessary, when the acknowledgement is older and deeper than any words available. Then he said, "Court is in recess, 45 minutes," and he walked out. In the gallery, there was a silence that lasted exactly 4 seconds before the room began to murmur. I heard Daniel's voice, sharp and confused, asking Voss something. I heard Voss respond in a tone that was now considerably more careful and considerably less confident than it had been 24 hours ago. I gathered my documents, I closed my folder, and I sat quietly while the room around me processed what had just happened. And I felt, for the first time in many months, something that I can only describe as the particular peace that comes when a very long effort reaches its turning point. The recess lasted closer to 90 minutes. When proceedings resumed, it was with a different judge, the Honorable Patricia Moore, who had been briefed on the case and who was notably thorough in her review of the record before saying anything at all. She read for 30 minutes at the bench while the courtroom waited. Then she looked up. She looked at Daniel and Voss. She looked at me. "I have reviewed the record," she said. "I have a number of questions." Her questions were for Voss. Judge Moore was not a woman who wasted words. She had the kind of precise, measured intelligence that I recognized immediately and respected deeply. The intelligence of someone who had learned through long experience that the most powerful thing in any room is clarity. She asked her questions one at a time. She waited for complete answers. She did not allow interruptions. Voss, to his credit, answered as well as a man could answer who had walked into a courtroom the previous day believing he held every card and was now being asked in exhaustive detail to account for the hand he had actually played. The first area of questioning was the retirement assets. Judge Moore walked through the timeline with Voss in a way that made absolutely clear to the entire room, in language that admitted no ambiguity, that the attempt to classify my military pension as a commingled marital asset was not supported by the documentation that had been entered into evidence. She cited 3 specific cases. She cited the relevant statutes. She asked Voss whether he had reviewed those statutes before filing his position. Voss said that his analysis had been based on the forensic accountant's assessment. Judge Moore asked whether the accountant had been given access to the complete financial records. Voss began to explain. Judge Moore said, "Yes or no, Mr. Voss?" Voss said, "Not the complete records, no." The second area of questioning was the characterization of my absences during the marriage. This was where it became, in the language of the courtroom, most consequential. The narrative that Voss had built, the narrative that Daniel had testified to, was predicated on the idea that my repeated absences from our home were a reflection of neglect, of choosing work over family, of being, as Daniel's witness had phrased it, more a soldier than a wife. That narrative had been allowed to sit in the record through the first day of proceedings because I had chosen, strategically, to let it sit. I had wanted to address it with evidence rather than argument, and now with my complete service record in the evidentiary file, Judge Moore was doing exactly that. She looked at the record. She looked at the timeline of my deployments. She looked at the nature of my service, the classifications that could be acknowledged without being detailed, the commendations that spoke to the significance of what I had been doing during those absences. And she said, in a voice that carried to every corner of that courtroom, "The respondents' absences from the marital home were the result of active duty military service at the direction of the United States government. They were not voluntary. They were not a choice between a career and a marriage. They were a constitutional obligation." She paused. To characterize these absences as evidence of neglect or marital abandonment in a legal proceeding is not only factually unsupported, it is, in my view, a misrepresentation of the record. The room was very, very quiet. I kept my hands folded on the table. I kept my face still, but inside I felt it, the full weight of 22 years, and the particular vindication of having someone finally, formally, and on the record say what was true. Voss tried to salvage what he could. He was a skilled attorney, and he made the best of a very bad situation. He filed motions. He raised procedural points. He argued with genuine legal creativity that the change in presiding judge warranted a fuller restart of proceedings. Judge Moore considered each point carefully, ruled on each one without apparent impatience, and proceeded. By 3 in the afternoon on the second day, the shape of the final ruling was visible. Not decided, not formally, not yet, but visible, in the way the terrain becomes visible when you get high enough to see the full landscape. I had been in enough difficult situations to recognize when the essential truth of a thing had been established, and all that remained was the formal conclusion. Daniel's position had collapsed. Not dramatically, not with a single devastating moment, but in the way that positions built on distortion tend to collapse, gradually, then completely, as document after document and ruling after ruling stripped away the version of events he had constructed and replaced it with what had actually happened. We were told that the ruling would be issued within 30 days. It came in 19. I was sitting at my kitchen table on a Thursday evening when my phone rang. It was the court clerk, notifying me that the ruling had been filed and that copies were available for pickup. I drove to the courthouse the following morning. I sat in my car in the parking lot and read the ruling from the first page to the last. It was 23 pages. Judge Moore wrote with the same precision she had demonstrated in the courtroom. The ruling addressed each contested asset individually, assessed the evidence specific to each, and arrived at conclusions that, taken together, represented something I had not quite allowed myself to fully anticipate. My retirement accounts, protected. My military pension, protected. The investment accounts I had contributed to during our marriage, divided according to the actual proportional contributions documented in the financial records I had entered into evidence. The house, to be sold, with proceeds divided according to the down payment records I had provided. And at the end, in a section that addressed the characterization of the marriage itself, Judge Moore wrote something that I have read many times since, and that I still cannot read without feeling the full weight of it. She wrote, "The respondent served this country with distinction for 22 years. Her absences from the marital home were not failures of commitment, but evidence of it, commitment to a duty larger than herself and larger than this proceeding. The court finds no basis for the characterization of the respondent's conduct during the marriage as neglectful or abandoning. The record reflects the opposite." I sat in my car in that parking lot, and I let myself feel it for a long time. When I finally drove home, I made a phone call. Not to a friend, not to a family member. I called my former commanding officer, a woman named General Patricia Reeves, who had been in my corner for 20 years and who picked up on the second ring. I told her what had happened. I told her about the courtroom, about Daniel's laugh when I walked in alone, about the documents, about Judge Caldwell standing up, about Judge Moore's ruling. General Reeves was quiet for a moment, and then she laughed. Not a mean laugh, the laugh of someone who knows exactly what it costs to get somewhere and is genuinely, purely happy that you got there. "Colonel," she said, "did you ever actually doubt it?" I thought about that for a moment. "No," I said, "but it is different when it is on the record." "Yes," she said, "it is." We talked for a while longer about other things, about life after service and what it looks like to rebuild something new. Before we hung up, she said, "You know what you did in that courtroom? You did exactly what we trained you to do. You walked in alone into an overwhelming situation with incomplete resources, and you used everything you had, and you prevailed." "I had a lot of documents," I said. "You had something better than documents," she said. "You had 22 years of knowing exactly who you are. That is not something an expensive attorney can match." I have thought about that a great deal since then, because I think that is really what this story is about. Not the courtroom, not the ruling, not Daniel's face when the documents were entered into evidence, or Voss's careful recalibration, or even Judge Caldwell standing up. All of that mattered, but what made all of it possible was something that had been built over 2 decades of choices and sacrifices, and hard mornings and harder evenings, an identity that was real, a record that was true, a self that could not be unmade by someone else's version of events, no matter how confidently that version was presented. Daniel laughed when I walked in without a lawyer because he saw a woman alone and assumed that alone meant vulnerable. He did not know that I had been trained to operate alone in environments that would have terrified him. He did not know that some of my most significant professional accomplishments had been achieved in rooms where I was the only person present who knew what was actually happening. He did not know that every one of the 22 years he had tried to use against me was in fact a year of building something that no court, no attorney, and no estranged husband could ever take away. He had married a woman he thought he understood. He had underestimated her for 12 years, and in a courtroom in November, with fluorescent lights and marble floors and a leather folder full of the truth, she had let the record speak for itself. I do not carry anger about any of it. I want to be clear about that. Anger is a weight, and I have learned over many years of carrying things to be very selective about what I allow to stay in my hands. What I carry now is something lighter and more useful. The memory of what it felt like to walk into a difficult room alone, to use everything I had, and to walk back out with the truth on the record. That is a feeling worth keeping. Whatever difficult room you are walking into right now, whatever situation has made you feel alone or underestimated or overlooked, I want you to remember this. Your record is yours. What you have earned is yours. What you have built through years of quiet, unglamorous effort is yours. And no one, no matter how loud they laugh when you walk in the door, can take that from you. That is what the quiet kernel is about. Not the uniform, not the rank, the quiet part, the part that does not announce itself, the part that simply does what is necessary and lets the results speak. If this story meant something to you, I want to ask you a favor right now. Share this video with someone who needs to hear it today. Maybe someone going through something hard, maybe someone who is being underestimated, or maybe someone who just needs to be reminded that the quiet ones are often the most prepared. Drop a comment below and tell me, have you ever walked into a room where someone underestimated you? What happened? I read every comment, and your stories matter here. And if you have not yet subscribed to The Quiet Kernel, now is the time. Every week, we bring you stories about real strength, real resilience, and real moments of truth. Hit subscribe, hit the bell, and I will see you in the next one. This is The Quiet Kernel. Stay quiet, stay ready. The truth always finds its moment.